if there's a decision to be made and a meeting needs to be called, we need to tell everybody about it. Corporate code says that if you have established regular meetings of the board of directors, the second Thursday of the month, every other 15th of the month or something like that, if you've established regular dates for your board meetings, then everybody knows about it. You don't have to tell anyone about it. Everyone's just supposed to show up at the assigned time. Or if you're at the meeting and say, well, we're going to meet next Tuesday the 16th at Jimmy's house, then you've established your meeting. You don't have to send out another notice for it. But if you're going to deviate from that, oh my goodness, we have an issue that's coming up. All of a sudden we just got a huge $55,000 bill from the water department. We need to talk about it, and we need to meet right away. So if you're going to have a special meeting that's kind of outside that norm, you need to be giving everyone at least 2 days notice of that. And that's required by the corporate code. You got to give 2 days notice for the special meeting. So you've done that. And go ahead.
Can I interrupt you for just a second, Jason? When Jason is saying you need to give everybody notice, the everybody he's talking about are all the board members. He does not mean giving everyone in the neighborhood notice about about every board meeting. Everybody who has to get 2 days notice for a special one are board members only. Sorry.
And that's right. And to the extent I make that mistake again, I'm just talking about your 5, 7, 9 people that are on your board of directors. We're talking about the brain of the corporation, not everything else. So absolutely right. You only have to give the board members 2 days notice. So if you've done that and we get together, are we allowed to move on? Can we conduct business? Can we make a decision about what we're doing? Well, the first question to ask is everybody here? So if we have a 5-member board of directors and only 2 people show up, can we move forward? We might be able to move forward and talk about it, but we certainly can't decide anything or make any decisions to direct the corporation to take action. This is what's called quorum. Quorum is the minimum number of people on your board for the board to be able to actually conduct official business and make decisions. So if you have a 5-member board, you're supposed to have at least half. That's what the corporate code says. Your bylaws could set something higher, and your articles of incorporation, but the corporate code talks about you need at least half. And your bylaws could bring it down to as little as a third. That's possible. We don't recommend it unless you have a really big board of directors, like 20 or plus people on it. But the general rule is you need half. That's kind of the default rule, and most bylaws say that. So if you have a 5-member board, you can't have half a person show up, so either 2 is too few, and 3 is just right. So you're going to need 3 to show up to conduct business in that regard. Now, the code doesn't really necessarily require that you have an agenda for what's going on, but that's really a good idea so that everyone really knows what we're going to talk about. So you can have an agenda and kind of have some orderly procedure to what is going on. So you have your agenda. I use the example of what are we going to do about how are we going to pay this water bill? Are we going to contest it? Good idea to kind of pass something out or have something distributed in advance that has that issue on it so everyone kind of knows what we're talking about at this meeting. Now, if we're going to vote on something, vote to file a lawsuit against the city to contest it, vote to go through some administrative procedure, vote to pay it, whatever it is, we have to decide, well, then how many people need to vote in favor? Generally speaking, the United States of America, majority vote carries. Makes sense? That's kind of how it works, and that's what the corporate code says. But you have a 5-member board, you have 3 people present, that doesn't mean you need all 3 to vote in favor. It's a majority of your quorum. Okay, of those if you have enough people to conduct business, you only have 3 show up, then again, you can't have half a person. You only get 1 vote in favor of something, it doesn't pass. You get 2 votes in favor of it, you've established a majority at that point, 2 of the 3 who were there, and you've gotten your majority. If all 5 show up, you would need 3 votes in that situation. I hate to bring math into it, but sometimes we have to bring some math in order to conduct our board meetings properly. Okay, so what happened at this meeting? We showed up, we had a quorum, we had an agenda, we talked about things, we made some decisions. How do we know what we did? Well, we were all there. Well, well, how does someone know 2 years from now what we did? We need to keep some sort of a record of what happened, so we need to have minutes. So usually, the secretary is the officer, or member of the board and officer, who's charged with keeping the minutes. And minutes doesn't mean transcript. Minutes means minutes, and the word has kind of lost its meaning over the years. It used to have a more defined, everyone knew what minutes were, I guess, 150 years ago. You do not have to write out at length. John said this, and he said that, and then he said something about his wife, and then he said something about his mother, and the whole argument that happened. You don't have to get into all that. This issue was proposed. You might be able to say raised by whom. It was discussed, and this was the decision that was made. That's the basic requirement for minutes. Sometimes it is helpful to put in a little more in there, but you don't need to be having 4 pages for a meeting that lasted 20 minutes long. And as mentioned before, minutes is one of the exceptions. Minutes have to be put into what's called the permanent records of the association. So minutes is one of those things that you probably should be keeping forever, because when the corporate code says permanent records, they mean permanent. So meetings of the board and other actions taken by consent of the board are something you want to put in your permanent records. The fact that you may not have something, minutes from 20 years ago, no one is really going to get you in trouble for that, but the point is to know what you've done in the past and how it occurred. Minutes is a very valuable tool, because the first thing, I spend most of my time defending lawsuits. And the first thing I ask for is, let me see the minutes so I know exactly what was going on, what happened at this meeting and when this issue came up. And that's the first thing the other side asks for, is give me copies of your board minutes. Am I running out of time?
No.
Okay. Now, how else can you vote? What if we can't get together? We can't get everyone there. Great thing about the corporate code says, you can meet basically by conference call, by Skype, by FaceTime. Code basically says, as long as the method of communication that is used is that everyone can hear and communicate with everyone else at the same time, you can hold the meeting and everyone is deemed to be present. This is for board meetings only. And the code allows that. Even if your bylaws don't talk about it, the code says you can do it. Code is silent on association membership meetings, so your bylaws or articles would actually have to provide for that to work. But as far as the board, the code says we're in the modern era now. If we want to meet by Skype or conference call, whatever, we're going to let people do it. Your bylaws could say no, even though the code allows us, we're not. I think that would be a bad decision to make, to amend your bylaws to do that, but you have a lot of freedom. In addition, we can't even get everyone by conference call, where they're out, but maybe we can make a decision via email. If you're going to make a decision outside of a meeting, that can happen. But if you have a 5-member board, make sure you're getting all 5 people to consent to this. If you can do that, and you send an email and you can get all 5 to consent to it, you've done it. You've done the action that needs to happen. Then you just print out those emails and you put them into the minutes of the next meeting and say, by the way, in the interim, we had this email conference because we just couldn't get together, and everyone said okay, and here it is, and we're putting into the minutes, and we're done. At this point, I'll hand it back.
Yes, so the next thing on the outline is about removal and replacement of board members, and I think that Jason and Kim may be talking about that in their election section.
We are.
So I was going to move ours along past that because they're going to have a whole section on elections. That's going to happen in the next room in the next hour, and in this room at the same time, we're going to have a discussion on covenant enforcement, enforcing the provisions of your documents. So if you've got more than one board member from the same association, you might want to split up, so that you can each hear some of the same information, from different information. The other thing I wanted to piggyback on what Jason just mentioned about getting the consents via email, that's called action outside of a meeting. And Jason mentioned that if you have a 5-member board, you should get emails from each one of the 5. And one of the things I want to just caution you about is when he was talking about minutes of the meeting, he was mentioning that you don't want to have a screenplay in your minutes. It shouldn't be Jason said this and Rob said that, and it should be just the actions. So when you are emailing back and forth about whatever the discussion topic is, that's the discussion that you're essentially having in your board meeting. You want to stop that discussion when you're ready to vote. and the vote and everyone's reply to all, yes, I accept, yes, I accept, yes, I accept, that should be a new email string. That should be what you save in your books and records. That should be what you put into your minutes. The whole discussion via email beforehand, you don't need to save any of that. You don't want to save any of that. That's your screenplay. You don't want that in your books and records. So just keep that in mind. We're going to shift gears. That was a little bit, sort of some tidbits about the board of director meetings. We're going to shift gears into the owner meetings. And Kim is going to spend some time talking a little bit about ownership meetings and what type of meetings we see in notices and what that looks like. You're going to hear some of the same words, notice, quorum. It's the same type of legal requirement, but a different number for the board meeting, a majority versus a third or versus whatever. For owner meetings, it's a different, but the same type of buzzwords. So take it away, Kim.
Good morning, everyone. I am Kim Gaddis. For those of you who were not in the other session, I am a partner at my firm of Gaddis & Lanier. I, too, have been practicing law for about 19 years. It makes me feel very old to say that 3 times today. But I do nothing but community association law, just as everybody else up here. And so I am going to talk to you a little bit about the types of ownership meetings. So as Jason was talking about the board meetings, now we're talking about when everybody in the community, all the homeowners, get to come together. And the law and usually your bylaws do require at least one meeting annually of all of your homeowners. So that would be your annual meeting, your annual homeowners meeting. You also probably have in your bylaws a provision for special homeowner meetings. Annual meetings, the provision usually will say in your bylaws when it will be held, either a specific month. Sometimes they say all annual meetings shall be held in the month of November at a time, date, and place that the board shall set. Sometimes it'll say, in the third quarter or within 120 days of the end of your fiscal year. You really need to look at your bylaws to see when your annual meeting needs to be held, and you need to hold it in accordance with your bylaws. Sometimes I'll have boards that say, well, we hold our annual meeting every spring because we like to have it by the pool. But the documents say you have to have it in December. So if you're going to do it differently, maybe you need to amend your documents to, make it to the month that you want to have it. Some documents are very broad and say that the time, date, and place of the annual meeting can be held, anytime at the board's discretion. So you need to look at your bylaws and just see when that is and do it accordingly. The special meeting provision usually provide that either special homeowners meetings may be called by the president or by 2 board members or by a percentage of owners by petition. Usually there's a provision that will say 15 or 20 or 25% of the owners can present a petition to request that the president or the board call a special meeting. But it's very important that you know that special meetings of the homeowners can only be called for a particular purpose, and if it's to vote on something, it has to be something that the homeowners have a right to vote on to begin with. Jamie touched on this in our previous session that homeowners don't have the right to vote on almost anything in the community. The board is the one who makes decisions and votes on almost all actions in the community, but the homeowners do have the right to vote on changes to your bylaws and your declaration of covenants, amendments, and sometimes with loans, if you need to borrow money for the association, oftentimes you'll need a homeowner vote on that. And a few very other small things. If they want to have a special meeting to discuss something or to give some input to the board, if they think the homeowners think the board isn't listening to them on a particular issue, you can have a special meeting to discuss. But if you need to vote, it has to be for a very particular small purpose. And the notice requirements of both the homeowners' annual association meetings and the special meetings are also usually laid out in your documents, and they're also codified. So if you are a condominium, submitted to the Condominium Act, or submitted to the Georgia Property Owners Association Act, there are 2 statutes out there that your community can be submitted to, either initially by your developer, which the Condo Act requires, or you can be submitted to the POA later by an amendment, sometimes of the board and sometimes of the homeowners. Those acts require specific notices of annual and special meetings. The POA and the Condo Act require 21 days advance notice of an annual meeting, so you have to follow that. And the special meetings require at least a 7-day notice under those acts. If you don't have, if you haven't given adequate notice and sent it out in time, if you're trying to hold an annual meeting and you give a notice 5 days in advance, first of all, that's not likely to garner much attention, and you're not going to get a lot of people at your annual meetings. And you're going to potentially be challenged because you haven't complied with the law and giving people sufficient notice. So you need to make sure you know what those notice provisions are and that you follow them, and really give people adequate time to schedule their days to come to your meetings. If you are a homeowners association, not subject to either of those acts, then your bylaws will dictate how many days you have to give. Sometimes you only have to give 10 days for an annual meeting. Sometimes they'll say between not less than 10 and no more than 30 days for an annual or special meeting. So really you have to look at your bylaws and see how many days you have to give before that notice. The notice requirements also have to go out to all homeowners of record, every single one. Sometimes I get questions about whether a developer or builders are entitled to notice of the meeting. Yes, they are. Every homeowner, every owner of a lot or a unit in your community is entitled to notice of that meeting, even if they're delinquent in the payment of assessments. They're entitled to the notice, they're entitled to come. They may not be entitled to vote if your documents, say you have to be eligible and have some eligibility requirements, which we'll talk about in our election session, but you absolutely have to give every single person, record owner, notice of your meetings so that you have the potential to get your quorum and that you don't have anybody challenging the sufficiency of your notice later.
Thanks, Kim. I wanted to piggyback on one thing that Kim said, which was about special meetings and the petition. I saw a couple of sort of heads nodding during the petition section. And normally we get questions from people who call us that want us to help them overthrow the government. I don't mean the real government, I mean the association board government. And they want to do so, and they want to force the election. They want to force the board to call a meeting. They want to force them out. There are very specific bylaw provisions that you might see related to that, and the petition is usually the first step of that process. The petition requires the board to call a meeting, and if the board does not do so, someone who has signed the petition is entitled to call the meeting. So a very, very detailed process, though, and you have to make sure you cross all your T's and dot your I's if that's the direction you're going in. And the association attorney is not going to help you. The association's attorney represents the corporation, represents the association, the community, and our clients are essentially the board of directors. We don't represent them individually, we represent them as the board of the corporation. So we're not going to help you overthrow the government of our own client. So normally that means you're coming out of your own pocket to pay your own attorney to figure that out.
Hey, Jamie, can I just
go for it?
One more thing on that? I do get a lot of questions, and even have gotten one today, though, about homeowners who are under developer control, and your documents give you specific timeframes within which the developer must turn over and transfer the control of that community to your homeowner elected board members. If the developer has not done that and your documents require them to do it by a specific date, you can, and there are lawyers, plenty of lawyers here that will help you do that, send a letter to a demand to the declarant saying your time has ended, you need to turn this over and here's why. And then you can force a special meeting in that way.
Exactly. And again, if they don't do that, again, you do the petition, and then you can force them to call the meeting, and if they don't, someone on the petition can do so. And the last comment I was going to make is some bylaws are silent regarding the amount of notice you have to have. Kim mentioned the Condominium Act and the Property Owner Association Act, and if your community falls under one of those statutes, the statutes describe the actual number of days. If you're a homeowner association and do not fall under one of those statutes, and your bylaws are silent for the number of days of notice, the Nonprofit Corporate Code, which regulates all nonprofit corporations in Georgia, does have notice requirements. It's a 10-day to 60-day notice if you're sending it out by, sort of registered first-class mail. If you're sending it in bulk mail, it's 30 days to 60 days. So the board can send out a very short notice time, 10 days, and we're having our annual meeting in 10 days, show up. And if they don't want to have an election, sometimes they use that short notice so that no one shows up. So then they can't have a quorum and they can't have an election. So sometimes that's a mechanism that we see. Rob is going to spend some time talking specifically about forcing the board to call a meeting, what those quorum requirements are, how many people have to show up in order to call that meeting to order, what that looks like, and what happens if you cannot attend the meeting, the membership meeting, the homeowner meeting, but you'd like to be counted. How does that work? So Rob Stein.
Thank you, Jamie Lyons. Good morning. I'm Rob Stein, partner in Lizego Johansson. Have been representing community associations for a long time, since 1989, about 26 years by count. I'm glad to be here this morning and welcome everyone. Ouch.
Don't put that in the minutes.
Ouch.
Yeah, don't put that in a minute.
Listening to my good friends up here who have been talking this morning, I think when it comes to meetings and quorums, if we want to guarantee a quorum at an annual meeting, all we need to do is at least hint that we're going to raise the assessment or raise it significantly, and we'll have people there. And they'll be there with their pitchforks and their torches. We'll hit our quorum requirements. But let me talk a little bit specifically about quorum, and how it works. There are percentages that are required to achieve quorum, and the Condominium Act and the Property Owners Association Act have a default provision in them that say that if your bylaws don't have a percentage in them, that it's a third. It's actually more than a third, but let's just call it a third. It takes a third of the community in order to call a meeting to order. And maybe let's talk about what if we don't have a quorum for a second. If we don't have a quorum, then we cannot do at our membership meeting whatever business is designated for that meeting. We can't vote on the budget if that's something. We can't vote on anything. We can't do any official business. Now, do we have to send everybody home at that point? No, we really don't. We could have what I like to call an informational meeting, where if we were going to talk to folks about the budget, about what's going on in the past year, maybe we're doing some PowerPoints or presentation, absolutely. Let's reward those people who've shown up that day, that evening for that meeting, and let's do that informational meeting. We just can't we can't bring the meeting to order, we can't vote on the board, we can't do any official business of that fashion, but we can still do everything else. As far as a quorum, like I said, if you're under the Property Owners Association Act or the Condominium Act, your quorum is probably a third, but your bylaws can provide a smaller number. State law allows for quorums to go as low as 10%, and even lower than that if you want it to. Who counts in the quorum? We've had a little discussion this morning about who's eligible and not eligible to vote. Somebody's delinquent, somebody's got a violation, we've suspended voting rights. Your bylaws will dictate whether or not they are part of the quorum for that day, whether the quorum, if it requires 30 people, whether their vote, their presence rather, would be a part of that quorum, whether they're eligible to vote, will all be dictated by your bylaws. Proxies, one of the items this morning is whether proxies count. What is a proxy? I don't think we've talked about proxies yet this morning. So, even if someone cannot attend, one of the great things that Georgia law allows is that they don't have to attend. They can give a neighbor, another homeowner, actually under the law, they can give it to anybody walking on the street. They can give a proxy, and that person can carry that proxy to the meeting and vote for them. And a proxy is just that. It's an authorization for someone to vote for me if I can't attend the meeting. No real magic words are needed in a proxy. Something simple like, I'm authorizing Kim Gaddis to vote for me at tonight's annual meeting, and I sign it and I date it. That makes it official. You know, we prepare proxies for our clients, everyone up here does, and we prepare what is usually a lengthy paragraph as a proxy, but all those words are important that we put in there because they accomplish a lot of different things in various different eventualities that might come up. If Kim can't come and she wants to hand it to Jason, there's all different things, but in its simplest form, all a proxy has to say is, I authorize somebody to vote for me at tonight's meeting, and I sign it and I date it. That's a proxy. And a proxy, how many folks here, by raise of hand, think to have a proxy, I have to have ink on paper and submit that? I mean, that's kind of a typical expectation. Yeah. Would you be surprised if I told you that if you took that proxy and you just faxed it in to the association that it's valid? It is. What if you made a copy of that proxy and gave it to your neighbor to take to vote for Kim to go vote for you at tonight's meeting? She had a copy, not your original ink on paper signature, the copy. State law says that's valid. What if you scanned it and emailed it in to, or emailed to Kim, or emailed it to the board, so the secretary of the association could vote for you at tonight's meeting. That's valid as well. What if you just sent an email in that says, I authorize Jamie or Kim or Jason or someone else to vote for me at tonight's meeting, and the email is dated just because when it's sent in, it's dated. That's a valid proxy. All those are valid proxies under Georgia law. So there's a lot of flexibility because our state legislature, and with the help of folks from up here over the years, has tried to make it easy for meetings to take place. We want meetings to take place. We want the business of the association. We want boards to be able to be elected each year. We want business to be able to take place. Proxies can be limited. If you want to give your neighbor a proxy that says, here's how I want you to vote, you could write on there and limit how they could vote. So there are all manner of things that you can do with proxies. Proxies are a legal document. I will sometimes have folks come into a meeting where someone's given their proxy, but it hasn't been filled out completely. It's typically not valid if it's not dated, or they haven't filled the name in of who it's being given to, little technicalities. So it's important to get a little help on the front end on a proxy to make sure the format's correct and to understand what has to be filled in so that it's valid. Meeting agendas, and I may come back to proxies slightly, but meeting agendas, there's actually no state law requirement for a meeting agenda. Sometimes your bylaws may set out the order of business for the annual meeting or other meeting, but there's no requirement for an agenda, but we think they're very helpful. To do a timed agenda is often great. You know, one of the challenges with a homeowner meeting is it can get off track, and they can get long, and folks are not paying attention to what's going on, and they interrupt and so forth. And so one of the things that I'll often do at the beginning of a meeting I attend is set out some procedure at the beginning of the meeting that says, okay, we're going to adopt some procedure for tonight's meeting. Anyone who wants to speak, our rules for this meeting will be, all you need to do is raise your hand. Once you raise your hand, at some point you will be recognized. And we're going to limit everybody to 3 minutes. You can have a second or a third term, but we want to make sure everyone has an equal opportunity to speak. And those are going to be our ground rules for tonight's meeting. Is there any objection to those rules? There never is. And those kinds of rules, just briefly stated at the beginning of a meeting, help bring order to the meeting. An agenda helps bring order to the meeting. It might say we're going to handle the treasurer's report from 7 o'clock to 7:15, and we're going to do the architectural report from 7:15 to 7:25. Having the agenda helps move things along, because then you can say to folks, oh, we're behind on the agenda. And that keeps things moving so that meetings do come to an end. Jamie, I'm going to turn it back to you. I think we want to talk about elections.
Yes, Kim is going to talk about elections in just a moment, but I wanted just to bring up a couple different points regarding the items that Rob mentioned. The first being that giving a proxy does not only give the person that you give it to the right to vote for you. They are you at the meeting. So when they walk in the door, they sign in for you as part of the quorum requirement as well. So giving someone a proxy means that they might be able to, the board, the association, might get to quorum because you then count as being present even though you're not physically there. Rob's there in my place.
Exactly.
So,
or you might not get to quorum because if the person who gave the proxy, if I haven't been paying my assessments and I'm delinquent and my vote's been suspended and I give Kim my proxy and she shows up with it at the meeting, she can't vote that vote. The board's going to say, nope, that Rob's delinquent, that's no good. Now, what if Kim's delinquent and I hand her my proxy and she goes to the meeting and she says, well, I'm delinquent, sorry, Kim, but I want to vote Rob's votes. That's fine, because she's standing in my place at that meeting.
So literally, when you give your proxy to somebody else, they are you. Whatever you could do or not do, they can do or not do on your behalf, which has nothing to do with what they can do for their own selves. So,
Jane, can I expand on that for 1 second?
Yes.
One thing, there's a common confusion, and Kim and I are going to go into this a little more in depth in our elections section, but I know some of you are going to have to divide up. Proxy is not the same thing as a ballot.
Right.
I give Rob my proxy and said, Rob, I'm telling you to vote for Tom. He can't make it to the meeting. I didn't vote for Tom because he couldn't do it, or he's there, and right when the ballots are being passed out, Rob gets a call, he has my proxy, and he has to leave. He didn't vote. The same way as that if I didn't make it to the meeting, or if I was there and I had to leave right before the voting, I wouldn't get the vote. So he really is, your proxy really is you. And if they can't vote or just forget to, you didn't vote, even though you gave your proxy.
Well, this is actually a very timely example that I have, because I'm working with an association right now where there's a fight about who's on the board. And there's a fight about who's on the board because one member of the corporation got a bunch of proxies. And the proxies said in it, Rob, I'm going to give you my proxy, but on my behalf, you're only allowed to vote for Kim and Jason. You're not allowed to vote for Frank and John. And when they got to the meeting, all that they did, the corporation, the association, board members, and the manager, all they did was collect the proxies. They never at the meeting had a vote. They never took a vote at the meeting with an election. They just looked at all the proxies and counted up who gave the right to vote to someone else, but never actually took the vote. There was never an actual vote at the meeting. So the people that gathered all these proxies and said, Rob, you're only allowed to vote on my behalf for Kim and Jason, Rob never ended up voting at all, ever, at the meeting. So the proxies were worthless. They never had an election. So the new people who think they got elected actually didn't. And the old people who really don't want to be on the board anymore are. So we're going to move into, I could literally spend probably 3 hours just on proxies. We could spend hours and hours on proxies. The only last thing I wanted to mention was that Rob had said that, if you do it this way, it's valid. If you do it that way, it's valid. If you do it in email, it's valid. Ultimately, the board of directors decides what type of proxies they're willing to accept. If you can't read a name, if you can't read the address, if there are rules in your bylaws or the board has created rules. Some rules say your proxy must be submitted by midnight the day before or 24 hours before. And if it's not, it doesn't count. So the board ultimately gets to decide what type of proxies they're willing to accept for the corporation. So I just want everyone to know you can come at them and say, no, Rob said it was valid. But the board ultimately decides what the validity of those proxies look like. Kim, we kind of spoke over your whole section on elections, so can you go quickly?
Absolutely. And we're going to, like we've said earlier, Jason and I are going to talk for an hour in the next session about elections. If you have any questions, then you can ask them there.
Okay, great. At most annual meetings, there are usually elections. So that's what we're going to say here. And if you don't have a quorum, you can't have an election. And if people want to get off the board, they're stuck. Unless they resign, if you can't have an election. Okay, let's go back to Rob. Okay. Rob's going to talk a little bit about voting at membership meetings and voting outside of the meeting.
Thank you, Jamie.
Sure.
So one of the critical things to do is to control the election process. I'm sure most folks in the room, like me, remember the fun that took place in the 2000 election between Bush-Gore and the hanging chads and all that. But what that really spoke to was what's critical is to control procedure, and it starts at check-in. You have to check, when folks check in for the meeting, we determine whether they're eligible, and the best thing to do right there is to have your ballots and hand them a ballot for the meeting. Because otherwise, if you're handing ballots out at the time of the election 45 minutes later, who are you going to give them to? You may not remember who gets a ballot, and you don't want to just hand out paper in the room because, of course, it's one vote per home typically, and if a vote's been suspended, et cetera. So the best thing to do is to control that right at check-in. Hand out the ballot at that point. That's your best procedure. So, voting outside of membership meetings. Again, our legislature has set up a process where almost anything that can be done and voted upon at a meeting can be voted on by mail or electronic mail. We can do most everything that we want to accomplish at a meeting away from a meeting, including an election itself. We can even do that electronically or outside of a meeting. So if there are things that you want to vote on, be it amendments, be it special assessments, other things that require membership vote, you almost always do not have to have a meeting to do that. You or your lawyer, your manager would look at your documents to see if there is a specific prohibition or a specific requirement to vote at a meeting. If there's not, then state law kind of gives this backup, allowing for anything that can be voted on in a meeting to be voted on away from a meeting. And the votes can be collected over time. It's a balloting process. It's a voting process that is strictly controlled by state law. There are 3 or 4 disclosures that have to go on anything that's voted on by mail in this fashion. It's Section 708 in the Georgia Nonprofit Corporate Code. So if you don't want to have to get it done in a meeting, if you want to get it done over time, or you can do it in a meeting and collect votes later, there's a lot of options for voting. Some of your declarations of covenants and condominium and bylaws will give a lot of flexibility to even collect votes at a meeting, combined with votes outside of a meeting. You want to look at these carefully because they're specific into what you can do as far as collecting votes. There are a lot of options. State law does allow for voting away from a meeting, and I think that's what we wanted to let you know.
Just a couple things. What Rob was talking about regarding check-in, I can't stress that enough. Check-in is probably the most important part of the actual meeting. And one of the things I wanted to mention is if Rob gives Kim his proxy, because Rob is not going to be at the meeting, when Kim shows up to register at the table and sign in, Kim should be signing in for herself and signing in for Rob, so that Rob is present at the meeting even though Kim is really his proxy holder. Does that make sense? She signs in for both of them. And if both of them are entitled to vote, Kim gets 2 ballots, one that she votes for herself and one that she votes for Rob. If she's not entitled to vote for herself, she just gets Rob's ballot. If Rob's not entitled to vote, but she is, she gets her own ballot. We don't really know whose ballot is whose. We just know that she gets 1 out of the 2 if one of them can't vote. Does that make sense? Okay. The other thing I wanted to mention is that Rob said if you're doing action outside of a meeting, it's a balloting process. There is a process to take action outside of a meeting with consent forms, which is different from ballots, both in writing, but very different requirements. So I just wanted to bring that up. You might hear your lawyer say something about ballots or consent forms. They're different procedures, but both voting outside of a meeting in writing somehow. We're going to open it up for questions. Yes, ma'am.
So, I know you mentioned that if you don't get enough votes to vote in a board member, but can you appoint a board member? And do they have votes?
So the question is, if we don't have, let's say, a quorum to have a meeting called to order, so we cannot have an election, how can we essentially put other people on the board? Can you appoint board members? Kim or Jason, you want to take that one?
I'm sorry.
Can you
Yes.
Jason's talking.
Well, so you have your situation.
Jason and Kim were talking to each other. Oy,
What I
wait,
was
I'm gonna
saying
have to
is,
separate you.
don't use the word appointment, because there's a technical meaning to appointment in the code. And for example, you're a declarant, if you're under declarant control, is appointing the board. But when the board has a vacancy, and many times, in many situations, the corporate code allows for, and the bylaws say, there's a vacancy, the board will fill the vacancy. Technically, the board is electing that person. They're not appointing that person. They're actually electing that person. And there's a section of the code that deals with when someone is elected by the board, how you remove them. And if they're elected by the board to fill a vacancy, how you remove them. So that's why we say don't use the word appointment, even though it's a very easy word, because it seems like one. But there's a technical meaning, and I had to fight, got a lot of briefs on that very issue.
Yeah.
So what can happen, what should happen is you don't have the quorum, and you got 3 of the 5 saying, we don't want to do this anymore. They need to resign, best to be done in writing. I hereby resign, blah, 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 blah. And then the 2 remaining
Can elect.
can elect
Right.
3 volunteers. If you have 4 volunteers, the 2 people remaining get to make that decision. But those remaining board members will fill the vacancies, hopefully from people who are willing to serve.
And they're only filled for the time that's left
Yes.
on the term of the resigning board members. So if they only had, the half of a year left, then those people that are filling that position will only stay on the board for that period of time.
But with that also, if the person who resigns has a year and a half left,
Right.
and they're having an annual meeting coming up in 2 months, if the board fills that vacancy, it's filled for the year and a half, unless the documents say otherwise.
Right.
So at the next annual meeting, you're not electing someone to fill that slot again. That same person who got elected by the board members to fill the vacancy stays on the board for that remainder of that term. And that's what I was talking about last session. If your terms get all messed up and you don't know who's on the board for which amount of time left, sometimes you have to press restart. A whole nother issue there. Yes, ma'am. So the question is about counting the ballots. Let's say we're having an election and we're having ballots for the election. The question was, do we take them out of the room? Do we go into a different space to be able to count them? And when I'm at the association meeting and I'm doing it, typically I do go to sort of a quieter area so I can focus on what I'm counting. Most of the time when there's an election and you're electing more than one person, you're having to count all the ballots so that you're sitting there, and if you have 5 people who were nominated and only 2 to be elected, you have to count each ballot separately. So you're saying, okay, 1 for Rob, 1 for Kim, 1 for Jason, 1 for Rob, and you're really having to focus. So typically I take it outside into a totally different room.
Unless, of course, it's a contentious meeting. And
Well,
I think
no, when I do that, no matter what I'm doing, whenever I'm doing, whether it's contentious or not, I usually bring in with me to the room to help me count someone who is from the community, not on the board, and not related to anybody who is nominated for election. Right. So I've got someone else from the contentious side and someone else that might be on the, the board side, whatever that sounds like to you, take that for whatever it means, and we all count together. Because there should be no reason not to do that. Everyone should be counting the same way, so it should all come out the same way. But yes, I do usually go into a separate room, and I usually bring different people from different sides of the vote. Yes, ma'am. Repeat the question, please.
Basically for...
Wait, the question is about executive session.
Yeah, executive session and how do you handle that. Just because something's in executive session doesn't by law mean that it's confidential. You have a right as a board to keep a lot of things confidential. And if we're ever in a lawsuit, I will fight harder to keep executive session things in confidence, because I'll say to the judge, there's 4 different issues that were discussed here. Only one determines with regard to this homeowner. We're going to redact everything else, and the court will usually back me up on that, but what you need to do is designate it as executive session, so people don't think I'm just making up which set of board minutes I want to redact things on. But the point about executive session is you designate it, you go in, you discuss issues, and you keep a separate set of minutes. Do not put at the bottom, and in executive session we did this. Keep a separate set of minutes on that. Don't publicize the executive session ones.
It should be kept by whoever keeps the regular minutes, but kept in a separate folder. So in a separate document, in a separate folder, a separate envelope, a separate, Gmail folder, whatever you want to do, but keep them different from the regular minutes, but just in the same spot, but in a different file or folder, so that you can tell what's what. We have to end this session right now, but our next session does not start until another 10 minutes, so you're welcome to come on up and ask our panelists questions. Thank you.